Hello, everyone, and welcome to the webinar channel of the Association of Certified eDiscovery Specialists. My name is Mike Quadraro. I'm the president of ACEDS. Today, we are joined by our partner, eDiscovery Today, our good friend, Doug Austin, for a webinar that is entitled Practical Applications of eDiscovery Rules. Before we get started, please know we love questions. We're happy to take questions. You can submit questions using the Q&A widget. There is also a slide deck today, and if you'd like, you may download it from the resource widget located on your screen. And with that being said, no further delay necessary. I am super excited to introduce Doug Austin from eDiscovery Today, who will take the presentation from here. Doug, please take it away.
Thanks, Mike, and welcome everybody to the webinar Practical Applications of eDiscovery Rules. I'm looking forward to discussing some important rules for eDiscovery and providing some practical examples of how they've been applied or misapplied. First off, a little bit about me. I am Doug Austin. I'm the editor of eDiscovery Today, which is a daily blog about eDiscovery, information governance, cybersecurity, and data privacy trends, best practices, and case law. I've been in the industry over 30 years, so I know a thing or two because I've seen a thing or two, and I've been daily blogging for over 12 years, so I'm either committed or I ought to be. And here are the rules I'll be discussing today. I'll also leave you with a list of recommendations at the end, and I'm going to do my best to save time for questions as well. So as Mike said, I encourage them, and please do put them in the Q&A box. Also, as Mike mentioned, you can download the slides, which have links to numerous resources, so I encourage you to download them so you can check those out. And of course, I always remind you that any ideas expressed by me here today are my own, not those of my organizations, clients, or partners. But I want to go a bit beyond that and also say that I'll be covering some cases that involve political and controversial topics. I'm not taking a position on any of these topics. I'm merely covering the eDiscovery considerations about them. Also, please don't consider anything I'm saying legal advice. It's eDiscovery best practices to consider, so please keep that in mind. So with that, we'll get started, and let's start our discussion of eDiscovery rules with this. My colleague and friend Tom O'Connor has regularly quoted the commercials with the E-Trade baby in webinars when we've discussed case law, where he says, "Read the rules, Shankopotamus." So as you'll find throughout this discussion, there are several parties who should read the rules, Shankopotamus. And our first rule is Rule 1.1, competence from the ABA Model Rules of Professional Conduct that set the expectation that a lawyer shall provide competent representation to a client. But the technical competence comes into play with Comment 8, which was amended in 2012, which says to maintain the requisite knowledge and skill, a lawyer should keep abreast of changes in the law and its practice, including the benefits and risks associated with relevant technology. So developing at least a basic understanding of relevant technology is now part of providing competent representation according to the ABA. And over the past 10 years, 40 states have adopted their own rules changes to adopt the duty of technology competence. You can check out a link to the rules in your state, courtesy of Bob Ambrosi's excellent Law Sites blog via the link at the bottom of this slide. If you're one of the 10 states that hasn't adopted it yet, you're still subject to ABA Model Rule 1.1, Comment 8, and we're about to see what happens when lawyers aren't technically competent. And we'll do so by starting with this example. And let's face it, when you're a lawyer and you find out that you've inadvertently produced client confidential information in litigation, it's a bad day. When you find out that confidential information is personal information on thousands of the wealthiest investors in your client's portfolio, it's an even worse day. And when you find out that disclosure is being covered by the New York Times, it's a lawyer's worst nightmare. So in this case, the lawyer working for an outside counsel firm representing Wells Fargo inadvertently produced tens of thousands of client names, social security numbers, account balances, and more for some of the most of the wealthiest investors in the portfolio. In a surprisingly frank affirmation filed with the court, she described how the inadvertent disclosure evidently happened. And it started with essentially using an eDiscovery service to conduct searches and set up the documents to be reviewed for confidentiality and privilege, which is typical stuff. But here's where it went wrong per the attorney's statement, where she said, "What I did not realize was there were documents that I had not reviewed. Unbeknownst to me, the view I was using to conduct the review had a set limit of documents that it showed at one time. Thus, I thought I was reviewing a complete set when I only reviewed the first 1,000 documents." She also noted it was her understanding that the vendor was going to apply redactions for documents he flagged as needing redactions, so she thought responsive documents that contain confidential information would be redacted prior to production. And I think the most telling statement in the affidavit is the sentence that says, "I realize now that I misunderstood the role of the vendor." So in other words, the attorney didn't realize that when she got to the end of the page, she needed to hit the next page button to keep reviewing, or she didn't realize that she needed to check out another batch to keep going. So was she improperly trained, or did she not pay enough attention during training? We'll never know. And not only that, she thought that redactions would be applied on documents that she tagged as needing redactions, but they weren't. How she expected the vendor to know what redactions to apply and where, simply based on a needs redaction tag, I have no idea. I guess mind reading is a skill she thought the vendor needed to have in this case. And she sums up the issue perfectly here by stating, "I realize now that I misunderstood the role of the vendor." Gee, you think? So certainly the lawyer made some mistakes in not understanding the technology and not understanding how to use the eDiscovery software. But the vendor should certainly be held accountable as well by not providing certain checks to help ensure that all documents were reviewed for confidentiality and privilege, and not raising the issue that there were documents flagged for redaction that hadn't been redacted. A few simple QC checks from the vendor could have saved the lawyer here. Communication is key. And here's an example of an email that I would typically send to a client when I'm asked to perform searches, where I clearly communicate how many potentially responsive documents there are. I even underlined it twice to emphasize it. Not only that, but I also typically try to follow up with a phone call to ensure that the attorney has received the message and clearly understands what they have and address any questions. And I like to employ this belt and suspenders approach to communications with clients as much as possible, by discussing requirements or issues with them, and then following up with documentation to confirm the understanding, or sending them an email with important information and following up with a phone call to make sure they saw the email and don't have any questions. I mean, after all, we all get so many emails these days, it's easy to miss important ones. So you want to make sure to follow up and confirm you're on the same page. Literally, if no one's driving the bus invariably ends up in a ditch. So one additional QC check that I like to perform at production time is to create a matrix, starting with the files that were originally collected. Then you count the files that were exceptions, those that were duplicates, those that were filtered for other reasons, such as non-responsive domains, those that weren't retrieved during searching as potentially responsive, those were reviewed and determined to be non-responsive, those that were reviewed and determined to be responsive but privileged, and finally, responsive files that are being produced. These are the typical buckets that files fall into during culling, searching, and review. And if the total of those counts matches the total number of files originally collected, great. If not, then something slipped through the cracks, and you have to figure out where the mistake was made and correct it. And if the Wells Fargo team had done that, they might have avoided this embarrassing, huge, inadvertent disclosure. So this next example involves a major redaction mistake from the DOJ. A few years ago, DOJ lawyers made a potentially serious error in a LIBOR rigging case involving a former Deutsche Bank trader when they mistakenly revealed the nature of testimony that he was compelled to give by failing to properly apply redactions. In the inadequately redacted portions of the brief, the prosecutors described the content of the trader's interview with the FCA. One sentence was highlighted in black and written in a gray font that was clearly legible. Other portions of the brief were blocked out with what appeared to be black highlighting, but were easily read by copying and pasting the contents of the brief into another text document. Word searches of the document returned text that was barely hidden behind the faulty redactions. The DOJ didn't find it. A reporter from Law 360 did. It's never good to have reporters find your redaction mistakes. So these next two figures illustrate what happened using a blog post I wrote. If you see the white space in this first screenshot here, that indicates something that was supposedly redacted. But when you use the black highlight or white text method in attempt to redact the document, all you have to do is highlight the affected area to see the redacted text. And the text is also searchable as well. And you can see what it's like yourself with the link to the blog post at the bottom of the slide by highlighting the white space once you get a copy of the slides. And by the way, it's not only the DOJ that's made this mistake. We typically see a couple of these instances every year that makes the news. News reporters all know the trick of highlighting the redacted area to see if they can capture any text. So it's a good idea to check your redactions that way and make sure you find them so that they won't. If you're working on an eDiscovery project, the good news is that you're probably performing your redactions within a review platform instead of natively within Adobe Acrobat or other platform where redaction mistakes can happen if you don't know what you're doing. So here's how redactions might look within a review platform where, as you can see, redactions might look like a gray box in the platform, so you can still see what's being redacted, but that section is obscured when the document is downloaded or printed. And here's an example of that, of a document that's been downloaded, or excuse me, exported out of the review platform. That grayed out box is now burned into the document so you can't see what's being redacted. And that's the advantage of using a review platform for redactions. So you certainly want to take advantage of that capability if you're doing it for an eDiscovery project. And so here are some of the common redaction failures to avoid in discovery projects. We already talked about the first mistake of failing to burn the redaction into the image, but the redactions also need to be carried forward to the text files and the native files too. Hopefully your eDiscovery platform carries the redactions forward automatically. Many do, but it's still a good idea to QC them before they're produced to make sure that they have been applied and carried forward. So our next rule is Rule 26b1 of the Federal Rules of Civil Procedure and the 6 proportionality factors. What's proportional in each case varies widely depending on the case. For example, proportionality for a slip and fall case would be considerably lower than for a class action involving hundreds of plaintiffs. In 2015, these 6 proportionality factors were moved up from Rule 26b2c, and they replaced the previous evidentiary standard of reasonably calculated to lead to the discovery of admissible evidence, which is no longer in the rules, though we still see it being used a lot. The 6th factor, whether the burden or expense of the proposed discovery outweighs its likely benefit, is one we'll drill into with some search terms discussion. So here's a case from my home state of Texas where the parties negotiated search terms, and 2 of the terms were what you see here. The exclamation symbol is the wildcard character in this case, and the W/10 means within 10 words of. So clearly it looked like the parties chose to add a wildcard to app to search for app, apps, application, or applications to go with phone or smartphone. Makes sense, right? However, there are more weird words in the English language that begin with that. So how many are there? There's this many. And this many. And this many. There's at least 308 words in the English language beginning with APP, and 304 of them are bad. Apparently, it appears the application of the wildcard was appealing when it wasn't approximate or even appropriate. It was appalling. See what I did there? This is known as getting wild with wildcards, and it's one of the most common searching mistakes I see legal professionals make. A much better search would have been to break out the individual terms with or separators to be much more precise, as you see in the example here. Keep in mind the parties negotiated this awfully overbroad term, so neither of them realized just how bad a search term it was. Fortunately for the defendants, Judge Andrew Austin, no relation, ruled that the defendants weren't required to produce everything responsive to the search results like the plaintiff wanted. They still had the right to review them for responsiveness, but the defendants did have to review a lot of extra documents they wouldn't have had to review, which was punishment enough. By the way, this doesn't mean that you should never use wildcard terms. It just means that you should know what to expect when you do use them. So here's a site called More Words. It's used by Scrabble and Words with Friends players to identify words they can use in those games. And as you can see here, you can do starts with and ends with searches to see what a wildcard might retrieve and avoid using those wildcards that are over-inclusive or under-inclusive. I provided links to examples for a starts with and ends with search, where all you would have to do is to substitute in the string that you want to look for. A very simple web search that would have taken probably 20 seconds to type out could have saved hours and hours of effort in the bank pass case. So let's look at some more bad terms, this time from the January 6th attack investigation. Again, this isn't a political discussion. It's focused on the search terms, which were really bad here. Frankly, I found Democrats and Republicans are equally able to be totally inept when crafting search terms. And so we'll start here with some likely under-inclusive search terms. As you can see in the second example, we've got a wildcard that actually isn't wild enough. The placement of it leaves out at least one form of the word, which is interfering. Because they placed it after the E instead of after the R. And here are some likely over-inclusive term examples. The first is set as a list of 7 states that are terms by themselves. That red "and" is just kind of an indicator of the list of terms, not a joiner of a search term phrase, if you will. And no other words are combined with them to limit their scope. So in essence, it's if the committee is saying any document mentioning any of these states is potentially conspiratorial, which obviously seems kind of ridiculous. It's also notable that the last 2 on this slide are more examples of wildcards getting wild. There's 127 words that begin with GAM and 70 words that begin with RIG. So again, these were overbroad search terms that a simple check could have enabled the scope to have been adjusted. And here's my probably my favorite common mistake in what I call the Department of Redundancy department search. In the first example, they had 4 searches that are specific proximity searches, but then they added a superset term, election, that essentially makes the other 4 searches irrelevant. The second example uses 4 specific government websites, but then it adds the superset.gov, which not only gets other federal government sites, but it also picks up state and local sites too, which is as many as 5,300 possible websites it could pick up. And I mean, I could be wrong, but I don't think too many of them have anything to do with the presidential election. So this next slide illustrates the first example. You also remember, you probably remember the Venn diagram and unions and intersections, right? We all learned them in school. So you've got the wildcard term of corrupt combined with the wildcard term of election with a proximity of within 5 words yields a nicely specific search, in theory at least. But when you add the superset term, that term and the other 3 terms become swallowed up by it. As a result, those 4 searches are rendered irrelevant. So unless the reasoning is to simply find out the number of documents responsive to these searches, this combination of searches doesn't fit well together. One great way of identifying search terms that might be overbroad is to run a search term report and determine the unique hit counts for each of the searches. A search with multiple terms is often derailed by a single overbroad term. So in the example on this slide, as you can see, the term illegal has a much larger number of hits than the other terms. So it could be an overbroad term that may need to be combined with other criteria to be more properly scoped. Now, we can't necessarily assume that just by looking at the list without testing the terms, but it could be a candidate to evaluate, and search term lists can help identify those. Now, speaking of testing, the best practice for determining whether a search term is properly scoped is to test it. Now, some of you are lawyers in the crowd, and I know you're thinking they said there would be no math when you decided to practice law, but you don't have to break out your statistics book. All you actually really need to do is input a few numbers into the right side. And here's essentially the three things you know to conduct a random sample. You need to know the size of the test set, the confidence level you want, and the margin of error you want. The size of the first test set will be the number of documents retrieved by your search. But you'll also want to test the documents that are not retrieved as well, which is known as the null set. And you'll want to test that to make sure to see if your search is missing relevant documents that may tell you that your search is underscoped. An appropriate confidence level is either 95 or 99%, and an appropriate margin of error is 5% or less. And typically 5% is fine. That's what I found in random samples I've done. And the end result is you don't really have to sample and test that much to obtain an acceptable statistical sample. Let's say you've got a search that retrieves 100,000 documents and you want a 99% confidence level with a 5% margin of error. If so, you only have to review 662 documents to get that. It's even less if a 95% confidence level will do, where you only have to review 383 documents. So if you have a much larger set, even the 1 million documents that's not retrieved in this example, you hardly have to review much more, even for that much bigger document set. Only 666 and 385 documents respectively. And if you're spooked by the 666 number, maybe the 95% confidence level is for you. By the way, many eDiscovery platforms support random sampling of results, but if you don't have that, here's a site that enables you to calculate the sample size you need. All you have to do is simply input the confidence level, margin of error, and population size. You can leave the population proportion alone. It's just about always good at 50%, and you'll get the sample size you need. It's essentially like using a calculator. And here is a site that enables you to generate random numbers for your random sample. So you'll enter the size of your random sample, the start and end of your range, which is typically from 1 to the size of your document set, how many columns you want the results in, and then you press the Get Numbers button. And as you'll see on that second screenshot, you'll get a list of randomly selected numbers, which can be record numbers in your set to be reviewed for the test. And by the way, that's why I selected one column. The default is 5. It enables me to paste the results into an Excel spreadsheet and sort the list, and then I can use that to then go pick the documents I want to randomly review for my sample. Again, you may not need to do this if your eDiscovery platform supports sampling, but it's good to see just how easy it can be. So obviously, with all this discussion regarding search terms, it should be remembered that there's another way to search for and review documents that's been around for years. In fact, over 10 years now, technology-assisted review has been court approved, and the technology and the workflows have become much more efficient and effective over that time. Machine learning, which is the same type of technology that's used by Netflix, Amazon, Spotify, and others to predict your choices in movies, music, and shopping, can also be used to help identify relevant documents and push those documents to the front of the review queue through a continuous active learning process. You just continue to review, and it continues to find more documents that are relevant based on the classifications you apply to other documents. Now, you may say you don't understand how it works, but given all the bad search terms we just discussed, it should be apparent by now that many lawyers and legal professionals don't understand search terms like they think they do either. So the idea that we all understand search terms is somewhat of a myth. And if you still think search terms are easier than tar, Here's just one of 25 searches for a case I covered earlier this year. So I'll give you a moment to look at it and ask you the question, can you tell whether this is a good search or a bad search? And honestly, I've looked at it for way longer, and I can tell you neither can I, and I've been searching databases for over 30 years now. So, it's really important to keep discovery proportional, and it's also important to understand the benefits and risks of relevant technology. TAR is highly relevant technology to discovery today, so it's important to keep that in mind as an alternative for your cases. So our next rule is Rule 26F, and parties are expected to conduct a Rule 26F conference, which has become better known as the Meet and Confer, about discovery planning. Parties are expected to meet and confer on things like the timing and scope of discovery, preservation of ESI, form of production, privilege protection, and so forth. Excuse me. And over the years since this rule was adopted back in 2006, courts are increasingly ordering parties to meet and confer on disputes before bringing them to the court. And we'll see one example of that in a moment. So one of the most popular ways to document the discovery plan is the creation of an ESI protocol. An ESI protocol memorializes agreement on a variety of discovery considerations, and those include things like definitions of terms, terms like ESI, producing party, requesting party, metadata, native file, to get all parties on the same page, who the custodians are and how they'll be handled, what's expected from the parties regarding preservation and what's not required to be preserved, such as inaccessible data on legacy systems or media, and maybe system files. Scope and manner of collection, including whether forensic collection will be required. All parameters of forms of production, including images, native files, unstructured and structured data, such as information in a database, and hard copy files. Certainly a detailed list of metadata fields to be included with the production. What you'll do about redactions, how they'll be handled and logged, including image and native redactions. Things like assertions of privilege and privilege logs. What assertions of privilege are allowed, expected format and content of privilege logs, how challenges to privilege designations are handled, use of a Rule 502D order to protect against waiver of privilege, and so forth. How Bates numbering and confidentiality branding will happen. Scope of deduplication to include considerations like global deduplication versus custodian level deduplication or email thread deduplication, and so forth. Defining parent-child relationships, including whether linked files from cloud-based Office Suite sources such as M365 or Google G Suite are treated as attachments. What to do about document exceptions like password-protected files and corrupt files that can't be processed. Things like search methodology and the use of TAR. And the level of detail here can vary widely, and they can include things like the actual proposed search terms and whether the parties will agree to exchange search term reports or not. Of course, if search terms are going to be defined in the ESI protocol, you just learned in our previous discussion what happens when you don't test them beforehand. Production methods and timing. So that could include things like how productions will be delivered. Will they be delivered via encrypted hard drive or SFTP transfer? And the handling and whether you'll do and support the handling of rolling productions. And then, of course, plans for identifying knowledgeable eDiscovery experts as liaisons to negotiate ESI issues going forward. And it's very important to have an expert to help with the ESI issues in your case, including the actual preparation and negotiation of the ESI protocol itself. And as you'll notice, the links to the bottom, Kelly Twigger's excellent eDiscovery Assistant site published a terrific 9-part series last year on ESI protocols, which covers many of the considerations. So I certainly recommend you check that out. So let's look at a couple of cases that illustrate the importance of an ESI protocol, how it needs to be comprehensive to cover your plans. And I just covered this first case about a month ago. In it, the defendants applied in August to implement their proposed protocol for the use of TAR after the application of search terms for its document production going forward. The plaintiffs opposed the use of TAR by defendants and instead requested that defendants be ordered to proceed with a search term and linear review, or be ordered to implement the TAR protocol to the full custodial set of documents. The defendants argued that by applying TAR after the applications of search terms is standard practice, and that as the party responding to discovery, they were in the best position to determine the best review methodology, and they cited 4 cases where that approach was approved. The plaintiffs argued that the application of TAR to the full corpus of documents prior to the application of search terms would create no additional burden on the defendants and would increase the accuracy of the review, and cited a case of their own. What's notable in this decision by the 2 special masters is that 3rd paragraph under the case link, where they said, driving our decision is the fact that the parties have not agreed to the application of TAR. More than a year ago, the court entered Case Management Order number 15 regarding electronically stored information, and that the parties shall promptly meet and confer regarding proposed revisions prior to implementation. So here the parties had an ESI protocol, but the defendant was trying to change their approach to TAR after agreeing to it. So the special masters ordered the defendants to continue with their originally chosen review method, linear search term review, saying because plaintiffs did not bargain for this at the outset over a year ago, it is inappropriate to force them to accept it now. So this case illustrates the importance of anticipating how you plan to conduct discovery and include it into the ESI protocol up front, not unilaterally try to change the approach after the fact. That's like going back on your word. And the case at the bottom of the slide, Nichols v. Noom, is a case from last year where the parties also had an ESI protocol. But the plaintiffs didn't expect that the defendant was going to regularly link to files in the cloud on Google Drive, which some people call modern attachments. Other people are not as keen on that term, but I'll let you decide whether it's a term you like or not. Regardless, they did that instead of embedding attachments within the emails. Because the handling of that wasn't explicitly spelled out in the protocol, Judge Parker in that case denied the plaintiff's bid to treat the hyperlinked files like attachments. So it's important to keep abreast of changes in technology and apply those changes to any ESI protocol that you negotiate. So our next rule is 2 components of Rule 34B, which discuss form of production. They give the requesting party the right to specify the forms in which ESI is to be produced, which is a very important right not to take for granted. It also gives the producing party some rights and responsibilities as well, including producing documents as they're kept in the usual course of business, producing it in a form or forms in which it's normally maintained or in a reasonably usable form or forms, and not having to produce the same ESI in more than one form, which means no do-overs for requesting parties if they didn't specify the form they wanted in the first place. So let's talk about the importance of form of production and how metadata enhances the form in which it's produced. And let's face it, when an eDiscovery professional like me walks by the TV and sees metadata expert testifying on the screen, it's like a dog seeing a squirrel in the yard. You know, I had to stop and check it out. And that was the case when my wife, Paige, I swear it was her, not me, watching the Amber Heard-Johnny Depp trial, and I saw a metadata expert testifying about Amber Heard photo metadata. Again, I'm not taking sides here, just pointing out a forensic analysis. The expert observed in his testimony that the software associated with the first photo of bruising on her face shows Photos 3.0, a photo editing software program, instead of the iOS version associated with the iPhone 6. That indicates that the photo was saved in an editing program. That doesn't prove 100% that the photo was edited, but it's not a good look. If the photo wasn't edited, the attorney should have produced the original from the iPhone 6, which would have confirmed that. The metadata accompanying the photo here enabled this analysis, which is why it's important to request native files with the metadata, so you've got as much information as possible about the evidence being produced. By the way, the expert's name in this case is Norbert Neumeister. He goes by Brian, which is a shame, because if there's ever been a better name for a forensic examiner than Norbert Neumeister, I haven't heard it. Now, certainly, while there's some room for doubt in that example, there's definitely no doubt in this one. And this was a case from last year where the plaintiff alleged that she was being sexually harassed by her supervisor, and she produced this image to the right, which on the face of it looks pretty bad. It was first produced as a PDF and then as a JPEG file. She claimed that she received the messages on her iPhone 5, but because the phone had a cracked screen and ink bleed, she claimed she couldn't take a screenshot of the message from the phone itself. So she claimed she took a picture of the text message exchange on the iPhone 5 screen using an iPhone X, which seemed fishy because the image didn't show screen cracks or ink bleed. It also didn't have any metadata that a picture from an iPhone X would have, and was determined not to ultimately be a photograph at all. But the clincher was the emoji she used. The heart eyes emoji depicted in the image is the version displayed on iPhones running OS 13 or later. The problem with that is that because she was using an iPhone 5, her phone only supported up to OS 10, which displays the emoji differently and can't possibly display the version of the emoji she included in the image produced. This was literally the case of the smoking emoji. And Judge Coate stated in dismissing her case, this image is a fabrication. So here's an example of a photo with me and my lovely wife, Paige, with the Golden Gate Bridge in the background. So how can you be sure this photo is legitimate and I didn't Photoshop it? Also, what's up with the cap I'm wearing, and why do I have such a big smile on my face? Well, the photo metadata can answer those questions. And here's just the metadata that's displayed when you push upward on a photo in an iPhone. It shows the date and time the picture was taken. It shows the type of phone and other picture parameters, including that it's stored in HEIF, High Efficiency Image File Format, which Apple uses to compress images so that they don't take up as much space. And it shows the geolocation of the photo, which proves it was taken at the Golden Gate Bridge. As for the hat and big smile, the date was the day after the Astros won the World Series. So you didn't think I would forget to mention that, did you? It's important to know, of course, that metadata is useful in many file formats, not just photos. It can tell you whether emails have been opened in Outlook. It shows formulas in Excel, and it can show track changes and comments in Word. And those are just a couple of examples of what you can get from metadata. So it's important to consider requesting native file productions to get the metadata, which can benefit your case. So I see we've got a question from the audience here that basically, I'll read it here, referring to FRCP Rule 34, when it's come to producing RSMF, what practical applications have you applied to comply to it while trying to keep review costs down and meet deadlines? Certainly, so RSMF is relativity's short message format, and certainly, some considerations there obviously is, and one of the reasons you're going to want to address production and form of production up front is you'll want to address considerations like this. Message formats like that, unlike emails, where email has all the entire discussion, the entire communication up to that point, because every email is in a string of emails. Each text message is a separate part of the conversation. So it becomes a challenge of determining where the conversations are and what's being produced. So you not only have form of production considerations of saying, am I producing just responsive text messages, or am I producing responsive conversations containing text messages? You also have to define what a conversation is, and you have to also determine whether whether you're doing searches where you're saying, okay, even if I'm doing a search where a text message is hit, I need to produce text messages around it to give that context. So those are some of the considerations that I think you have to address. And again, the ESI protocol is a great place to address it. And I see someone says they've lost all audio, but hopefully the rest of you can still hear me. So I will continue moving on, hoping that's the case. So our next rule is another component of Rule 34B, which addresses objections, and it was added in 2015. It requires parties objecting to discovery requests to state with specificity the grounds for objecting to the request, including the reasons, and also to state whether any responsive materials are being withheld on the basis of that objection and permit inspection of the rest. An objection that states that the request is overly broad, unduly burdensome, disproportionate to the needs of the case, and not reasonably calculated to lead to the discovery of admissible evidence, there's that phrase again, is considered a boilerplate objection, and courts are increasingly finding these objections are waived. Parties no longer get a second chance to object when using boilerplate objections. And here's a case that illustrates that, where defense counsel for the Illinois Department of Corrections eventually produced its entire production, a whopping 4 pages of documents, after which plaintiff's counsel speculated that the defendant had either not conducted a good faith search or had destroyed documents. As Illinois Magistrate Judge Jeffrey Cole, who regularly has some pointed and entertaining observations, stated, once the charge of spoliation was made, things, to quote Ron Burgundy, really escalated quickly. While that's a clever line, what he said about the defendant's objections was more important when he said, first things first, time and time again, attorneys are warned that boilerplate objections are unacceptable. They're tantamount to not making any objection at all. The boilerplate answer constituted a waiver of whatever objection, if any, IDOC might properly have made. Boilerplate objections, as we've shown, are ineffectual in all contexts. So that's indicative of the type of responses that courts are making in response to boilerplate objections these days. They're almost always turning them down, and so you want to avoid making them. Otherwise, you'll probably lose the right to object at all. So we've been showing examples of how not to do things, but here's a good example of how an objection should be made. In this case, involving alleged overcharging for shipments and a request for detailed package-specific discovery for 5 years' worth of data, defendant UPS provided specificity in their response, explaining that the data was live for only a limited time and then it was archived on backup tapes. They also provided an estimate of $120,000 just to restore the backup tapes. In addition to that, they also offered an alternative solution, providing an estimate of the number of packages for a 6-month period. Why 6 months? That period was selected because UPS's contract's terms stated that a customer must give notice of a billing dispute within 180 days or the issue is waived. So in this case, Judge Whalen agreed with UPS that the request would be extraordinarily burdensome and ordered the parties to meet and confer. Of course, one of the most common types of eDiscovery disputes every year involve requests for sanctions for failing to preserve ESI. And the FRCP rules involving sanctions were updated in 2015 in the form of Rule 37E, which considers sanctions because a party failed to take reasonable steps to preserve ESI, and that ESI cannot be restored or replaced through additional discovery, and also when another party is prejudiced by the loss of that information. But to get harsh sanctions, the court must now find intent to deprive, which could lead to jury instructions regarding whether it may or must presume the evidence was unfavorable to the party. And by the way, the difference between may and must is huge, so keep that in mind. Or it can even be dismissal or default judgment in the case, and I've seen examples of all of that. The intent to deprive standard eliminates harsh sanctions, though, for mere negligence, even if it's gross negligence. So while the tougher standard makes harsh sanctions more difficult to get, they do still occur. In this case, when the defendant learned the FTC was investigating his company, he instructed the company leadership to start using ephemeral messaging platform Signal and encrypted email platform ProtonMail to communicate. He didn't disclose use of those platforms when he was deposed, and all the individual defendants erased signal from their mobile devices before they were produced, removing any possibility of collecting any signal messages that were not yet automatically deleted. Judge Lanza didn't buy the defendant's claim that they switched to signal because they noticed hacking attempts of a former associate and found clear intent to deprive, awarding an adverse inference instruction for the defendant's intent to deprive the FTC of that evidence. And here's a case that shows even if you do a lot, you can still receive sanctions for what you don't do. This case involved an inadvertent spill of 3 million gallons of wastewater by an EPA-led contractor crew in the inactive Gold King mine that polluted rivers in Colorado, New Mexico, and in Utah, including on the Navajo Nation lands. That's a big disaster. The EPA issued a litigation hold 6 days after the blowout of up to 1,000 employees and sought to preserve text through this process on approximately 500 cell phones. Good, right? The problem is that they failed to preserve ESI for two of the most important custodians in the case, the two on-scene coordinators, and they lost mobile device data from iPhones and an iPad, as well as the OneDrive account of one of the coordinators, which meant that over 800 photos and 120 documents related to the Gold King mine were lost. That's a disaster within the disaster. So even though there was no intent to deprive demonstrated, the court did still sanction the federal parties and permitted the plaintiffs to introduce evidence of the federal parties' spoliation of mobile device data at trial, while they also still allowed federal parties to introduce evidence on their own efforts to preserve the data as well. So it's a privilege to bring you this next rule because it's about privilege protection. See what I did there? Anyway, Federal Rule of Evidence 502 has two subsections that are particularly important. Rule 502B provides protection against waiver of privilege for disclosure of privileged materials if it's an inadvertent disclosure, if you take reasonable steps to prevent disclosure, and if you take reasonable steps to rectify the error, which usually means request to claw it back promptly. Rule 502D goes considerably beyond that in protecting against waiver of privilege, in essence stating that getting a 502D order in your case will protect against waiver of privilege even if you aren't so careful and reasonable. And it also, very notably, extends to every other federal and state case as well. That's a huge level of protection, and it makes getting a 502D order a must in cases today. All right, so now I have to be honest and admit that this first example actually has nothing to do with Rule 502D or 502. It's a state case. But I wanted to cover it because, one, state cases and rules are important too, and it's important to know those. And two, I mean, let's face it, this story about Alex Jones is simply too good not to cover. So what happened here is that Alex Jones' attorneys mistakenly produced an archive containing his text message history over a 2-year period, which directly contradicted his statements that he didn't talk about the Sandy Hook tragedy over text. Why the statement of the plaintiff's lawyer referring to 12 days ago is so important is that Texas Rule of Civil Procedure 193.3D states a party who produces material or information without intending to waive a claim of privilege does not waive that claim under these rules or the rules of evidence if, within 10 days or a shorter time ordered by the court, after the producing party actually discovers that such production was made, the producing party amends the response, identifying the material or information produced and stating the privilege asserted. So when Alex Jones' attorneys failed to read the rules, Shankopotamus, they waived privilege on the mistakenly disclosed materials, leading to Alex Jones' I think, somewhat sarcastic response of, "This is your Perry Mason moment," to indicate that he'd been caught. Mistakenly producing the entire 2-year archive of text messages certainly also falls to ABA Model Rule 1.1, Comment 8, about technical competence. And that's one of the things about a lot of these examples. They apply to multiple rules for eDiscovery best practices. There we go. So here's another example, this one involving Meta, aka Facebook. There was a 502D order in this case, but the plaintiffs still tried to compel Meta to produce in unredacted form 9 emails or portions of emails that were part of an extended email exchange that Meta clawed back from production. In this case, their argument that a previous production of the emails, which happened before the 502D order in this case, waived privilege, was rejected by Judge DeMarchi, who found that Meta took reasonable steps to prevent disclosure. However, she did rule privilege was waived on one communication that had been included in a complaint in the FTC case, as Meta was using it while trying to protect privilege elsewhere. So had Meta used a 502D order in that earlier case, they might have been able to protect that communication too. So here's a model 502D order from retired Magistrate Judge Andrew Peck, who's now Senior Counsel for DLA Piper and my regular colleague on monthly case law webinars. Judge Peck states that a 502D order is a get-out-of-jail-free card when it comes to privilege waiver, and most of the time you hear him speak, he'll probably bring up the importance of having a 502D order at some point. I think he's even thrown out the M word of malpractice in not having one. His example that you see here and another are contained within the Sedona Conference principles that are linked at the bottom of this slide. So that brings me to the last rule I'm covering here today, which is Rule 901 regarding authentication of evidence. We're seeing more cases involving disputes over evidence authenticity, and Rule 901A states that you must produce evidence sufficient to support a finding that the item is what you claim it is. Metadata is a great example of evidence to support that claim via the distinctive characteristics example in point 4, but testimony can also be used if it's from a witness with knowledge. So let's discuss 2 cases involving authentication of evidence, and both happen to involve Facebook messages. The first case involved claims of racist and homophobic Facebook messages allegedly sent from one high school student, Harper, to another, Edwards. After JSA failed to find any evidence of the alleged messages when searching Harper's phone, and Edwards' father failed to provide any evidence, they reinstated Harper, but the Edwards then proceeded to file suit. JSA served written discovery requests to the Edwards, seeking production of ESI from his Facebook Messenger account that could prove or refute the authenticity of the alleged messages. But they never got any response until the Edwards were sanctioned. And only then did they make purportedly responsive productions to JSA, which also included 2 digital forensic expert affidavits, but both of those were filed after the expert designation deadline. The Edwards also acknowledged that he had deleted his Facebook account. So Judge Jordan sanctioned the Edwards, essentially prohibiting them from offering any evidence of the messages, which was essentially their case. In this example, which is a criminal law case, it's technically a New Mexico state case, but their rule of evidence 901 is virtually identical to the federal rule, so it still provides a good example. And here the state sought to introduce evidence of communications in the form of screenshots between a 17-year-old child and a man named Erickson regarding an accident where the child was accused of driving drunk and crashing into a tree. The state alleged these communications took place on Facebook Messenger the day after the incident involving Erickson's vehicle. The state sought authentication of the social media evidence through Erickson's testimony as to his personal knowledge of both the accuracy of the screenshots and his history of Facebook Messenger communications with the child, as well as through the contents of the messages themselves. And the evidence was admitted over the objection of child's trial counsel. But the Court of Appeals reversed that, finding the state had failed in its burden to properly authenticate the messages. However, on appeal of that ruling, the Supreme Court of New Mexico found that the state's authentication showing was sufficient under New Mexico Rule 11901 to support a finding that, more likely than not, the Facebook Messenger account used to send the messages belonged to child, and that child was the author of the messages. So the court reversed the Court of Appeals ruling and reinstated the child's delinquency adjudications. So this case also shows that not all courts agree on what is considered to be authenticated. So you really want as much evidence to authenticate as you can get. So with that in mind, let me give you some recommendations here. The first, and I've said it a few times here, is read the rules, Shankopotamus. You've got to know the rules and understand what they require, because they're probably the most important driver of eDiscovery best practices there is. You need to understand the technology, get the software training, and pay attention during the training. That's not a time to be multitasking. And if you're managing eDiscovery projects, you want to make sure your team gets the training and pays attention and understands the technology, because you're ultimately responsible for it. Don't get wild with wildcards, and test your searches. And as I've shown you, hopefully in this past hour, it's not as difficult to test your searches as you might think. You can do some very quick and easy things to determine if your searches are improperly scoped. Consider ESI protocols, but cooperate on changes and keep them current. So certainly know going in how you want discovery to be conducted, and try to get that into the ESI protocol up front. And then if you want to try to make changes because you didn't anticipate something, cooperate on the changes. Don't try to unilaterally push them through. Consider requesting native files to get the metadata, which is certainly, hopefully, a couple of the examples we provided there really illustrate how much the metadata can be useful in truly understanding the data with not just photos, but all sorts of types of files. Don't make boilerplate objections. They're tantamount to no objection at all, and that tantamount to no objection at all is phraseology that I've seen in several rulings on objections. So courts are regularly, almost always these days, are basically disallowing boilerplate objections and waiving objections entirely. Obviously, take your preservation obligations seriously. Spoliation can lead to sanctions, even if you don't have intent to deprive, as we saw in the Gold King mine case. You take some steps, but if you make some obvious and important errors, you can still be sanctioned at some level. This point says consider a 502D order, but I would say strongly consider a 502D order is a must in your case to protect against waiver of privilege. It is truly your get out of jail free card. Be prepared to provide ample information to authenticate your evidence. As we saw in this last case, not every court agrees on what's considered authentication, so you want to make sure and cover your bases as much as you can. And then finally, one last thing I'll mention is, to continue to educate yourself. I always recommend read 5 to 15 minutes per day and attend one webinar per month. You just attended your webinar, so good job there. And you'll find that plenty of resources are available for reading and attending webinars that are all free. So you won't have to pay a dime to do so. You can certainly go to eDiscovery today, every day, because we have topics every day to cover, and continue to advance your education there. And looks like we have a minute or two left. I don't see any other questions here. But if you have any really quick, I will try to address them. Certainly, if you think of any after the fact you would like to pose to me, I'll point you to the speaker slide. My email address is there, and I certainly would welcome a question offline if you have one. And so here's a question. Many of the vendors offer their own version of TAR, but exactly how each of their technologies work is a mystery. Has there ever been a study to determine which vendor's TAR is most accurate? Well, the first question is really getting an agreement on what's considered most accurate. To my knowledge, there's not been a study to determine which vendor's TAR is most accurate. I think what I would certainly recommend anytime you're looking at a platform that includes TAR is to try it out. And you don't have to try it out on a production. You can try it out on production on a document set that's been produced to you, or you can try it out on a case that has been used in the past that you want to kind of get a sense of, with a known data set. So in essence, what you need to do is really pick the TAR technology that's right for you, and you'll only know that by testing it out. So I don't see any other questions here, and this is my last webinar of the year, so I'm going to do my little happy dance and say happy holidays from me and eDiscovery today, and probably turn it back over to Mike, who I assume is still on, right?
I am right here, my friend. Fantastic presentation today.
Thank you.
All right, everyone. Thanks for joining us on the ACEDS Webinar Channel in celebration of Doug's last webinar of the year. Happy holidays, of course. Happy holidays to you, my friend. And thank you for a great presentation. Everyone, please check out Doug's blog, eDiscoverytoday.com. Sign up, register, subscribe, whatever word you choose, do it. Doug, have a great holiday. Everyone, have a great holiday. Thank you for joining us today. Please check out aceds.org for a complete list of upcoming webinars. Have a great day, everyone. Be kind to one another.
Happy holidays, everybody. Happy holidays, Mike and Deja. Bye, everybody.